The two dockets on the murder of Orlando Pirates star Senzo Meyiwa have come into question at the High Court in Pretoria. The defense attorney, Advocate Malesela Teffo, says there were two separate teams investigating what could have happened on the day that Senzo Meyiwa was killed. Teffo says the first docket has a theory that robbers came into the house, while the other docket states that people who were in the house, including Kelly Khumalo, must answer for the death. To understand this now, we're joined by legal expert Dr Llewelyn Curlewis. Doc, thank you very much for your time. Let's start with that. The existence of two separate investigations resulting in two dockets. Is that something that you have heard before? It all surrounds one case.
Well, it's not uncommon. It has happened before. It's obviously the question will be posed exactly why this happened in this instance, and maybe there's a reasonable explanation for it. That's the first point of departure. The second issue is obviously the law and the court will not work with theory. They work with evidence. So ultimately, the evidence will be weighed up to decide whether the state has proven its case beyond a reasonable doubt. But we can be sure of the fact that Advocate Teffo and the defense team will definitely investigate and try to downplay the state's arguments surrounding the credibility of the evidence by comparing these two dockets and the contents thereof. Now, the worst case scenario for the state is that there might be conflicting evidence, conflicting affidavits by some of the persons, witnesses mentioned in these various dockets. Now, if that is so, obviously they will have to explain why they have made different affidavits in these two dockets. So ultimately it will boil down to credibility of the witnesses in the docket. Yeah. But to come to the court and say, well, there are two theories, unfortunately that will not cut the chase, because ultimately the court works on evidence, not theory.
All right, Doc. So two dockets existing for one case. Yes, it may not be something that we're seeing for the first time, in your words. However, the narrative or the story between these two dockets is so completely stark that the one says there were intruders, for which there is a court case that is now ongoing. But the other one, if indeed it does come to light, it completely exonerates the very people who are before court right now, and it puts a completely different set of suspects before court. Again, I ask you, is that something that will be strange?
Yes, no, of course. The explanation will be requested by the presiding officer. You can be mindful of the fact that the mere fact that there are two possible scenarios will be the argument by the defense. And remember, because the onus of proof is on the state beyond a reasonable doubt, the threshold for them to be successful with a conviction is so much higher in comparison to a civil law case. So where there is doubt, the defense must get the benefit of the doubt, and the accused must be acquitted. So definitely the argument will be posed to the advantage of the accused. But that being said, remember, the question that comes to my mind is exactly who have formulated that theory. Is that a theory that the defense lawyers themselves created when they perused these two dockets, allegedly? Or is it the opinion of one of the investigating officers in either or both of the two dockets? Because if it's only an opinion, then that is exactly what it is. Remember, opinion evidence is, as a general rule, inadmissible in our law. So a court does not have to entertain the opinion of even the investigating officer, because it's merely an opinion evidence. So it will depend on the contents of the docket. But sure, I do agree with you, it does raise suspicion, and they will have to come up with some explanation one way or another for the two different dockets and its contents.
What you've just said, Doc, is very important, because your words that opinion is inadmissible. In other words, you can't rely on it in a court of law. should Advocate Malesela Teffo then have said what he said in court about Kelly Khumalo, and that is that we are going to bring a witness who is going to tell this court that there was some kind of meeting that took place there, and that it was Kelly Khumalo who shot Senzo Meyiwa by mistake with a gun that was brought into the house by another person who was within the house. This is Longwe Twala. Should he have said what he said, and should the court, by the way, have allowed him to say that, given what the judge said, and that is that we are not going to deal here with hearsay evidence. If you want to do that, you should bring a substantive application.
Yeah, remember, first of all, we are dealing with a criminal case here, so people's lives are at stake. If they are convicted, chances is very likely that they might be incarcerated for life. So the courts tend to be more liberal in their allowance of certain evidence in order to give the defense every opportunity possible to put up a version or an explanation of the events. That's the first thing. The second thing is, if such a witness is available, then definitely that witness will have to come and testify in support of the defense and the accused. And the state prosecutor will then obviously have to cross-examine to see what credible evidence, direct evidence this witness can give. Remember, when you talk about opinion evidence, this is not a question of opinion evidence. If they have a witness available and that witness comes to testify, viva voce we call it, in other words, oral evidence, that is direct evidence before a court, open court, which can be cross-examined and properly tested. And then, depending on how good such a witness stood under cross-examination, a specific weight will then be attributed to that witness's evidence, which will, in conjunction with all the other documentary evidence, forensic evidence, evidence of other witnesses, then form a puzzle, so to speak, that hopefully will give the correct answer and the truth to the court to make a decision.
So in simple language, Doc, I mean, the legalese sometimes can be so confusing. So what you're saying is that Advocate Malesela Teffo was well within his rights to say what he said in court about Kelly Khumalo, provided that he can actually prove it in court.
Exactly. Because can you think of the situation where when then called upon to testify or the defense to put their version before court, all of a sudden they have a 360 degrees turnaround and say, but listen, we said to the court we have this witness, but all of a sudden now we do not have that witness. So in actual fact, we were actually not playing open cards with the court because no such witness existed. It was merely an attempt to try and confuse the other witnesses or to create a scenario where there might be confusion of some sort or even a discrepancy in the various versions to the advantage of the accused. In that instance, the court will frown upon him specifically and maybe even entertain a question of his legal ethics towards the court and refer it to the Legal Practice Council. So for his sake, I hope he can obviously produce what he has advised the court he intends to do.
Sure. And then, as a person knowledgeable in this field, Doctor, talk to us about what we have heard in court right now about the work of the police, the picking up of DNA.
Police forensic investigation have always been a concern, especially over the last decade. So this is nothing new, and that should be a concern for the prosecuting authority. I mean, you can have the best prosecutor in court and you can have the best witnesses available, but if the forensic material ultimately does not substantiate and corroborate the version of the state and its witnesses, then, especially if that was placed in dispute, which it was in this instance, then purely based on the principles of law of evidence, the advantage must always swing in favor of the accused. Because obviously, as I pointed out earlier on, we are talking about people's lives here. A court would rather err on the side of the defense than see to it that an accused person goes to jail for the rest of his life where the state's evidence was not supported by, for example, in this instance, forensic material. So the investigating officer and the forensic personnel on the scene must explain if there are anything untoward in the results that they produce to court in their, say for example, Section 212 affidavits. In simple terms, it means only one thing. If the court cannot be satisfied beyond a reasonable doubt, meaning anything up to 85, 90% that the state's version is the truthful version, then in terms of law, international law, as well as our law over millennia, is that the accused must get the benefit of the doubt. It's as simple as it gets.
I don't know how closely you've been following the testimony or the cross-examination inside court, Doctor, because when you talk about that forensic material, the question to you is how well or badly are police doing thus far, given that this police officer, who was among the first to arrive at that scene, he did not take a swab off the door where the alleged intruders entered. He took some 8 photos. Does that inspire confidence?
No, it does not. In actual fact, it proves quite the contrary. I must be straightforward. I have not followed each and every day of the events and the cross-examination because obviously I'm in court myself on a daily basis doing my own litigation.
Yeah.
But from what you have said and from the information that came to my knowledge, this should be a contentious issue and should definitely count in favor of the defense against the state's version. So, especially where everything was placed in dispute. And in this instance, that is exactly what the defense did. From the outset, they placed the state to prove its case beyond a reasonable doubt by disputing everything and basically remained silent. So, everything, every single piece of evidence must be proven by the state. Otherwise, the acquittal will follow.
Legal expert, Dr. Llewelyn Curlewis, thank you very much for your insights on this. I still can't get over what he said, that I hope for the sake of him, that's Advocate Malesela Teffo, he can prove what he said.